Today on Forbes, the cops seized his $86,900 life savings for no reason. They picked the wrong Marine. It sounds like the opening of the Netflix hit movie Rebel Ridge, but it happened in real life, and the consequences are still playing out in the Nevada courts. On February 19th, 2021, retired Marine Stephen Lara was making the 1,400-mile drive from Lubbock, Texas, to Portola, a small California town near Reno, Nevada, where his teenage daughters lived with his ex-wife. Early in the COVID-19 pandemic, Lara, now 42 years old, was laid off from his hospital systems administrator job in California and moved in with his parents in Lubbock to save money and to save up for a house. Lara had driven this 4-day round trip dozens of times, and it had become almost routine. This time, however, he was pulled over by the Nevada Highway Patrol on I-80 near Sparks, Nevada, about an hour from Reno, ostensibly for following and passing a tanker truck too closely. He wasn't issued a traffic ticket or warning, let alone arrested or charged with a crime. Yet the 90-minute encounter ended with the officers seizing Lara's life savings, some $86,900 in cash he had in a Ziploc bag, and sending the money to the Federal Drug Enforcement Agency for potential, quote, civil forfeiture. What that means is that despite the fact Lara was not charged with the crime, the feds could legally keep his money, kicking back $69,520 of it to the Nevada Highway Patrol as a sort of finder's fee. More than 6 months later, Lara got his cash back, but only after the Institute for Justice, or IJ, a libertarian not-for-profit law firm, sued the DEA on his behalf. Now, with IJ still representing him pro bono, he's asking Nevada courts to rule that the state's constitution, which protects property rights, bars the Nevada Highway Patrol from participating in the, quote, equitable sharing civil forfeiture program run by the feds, something almost all states now do. Earlier this year, Lara won a preliminary round in his Nevada case when a trial judge rejected the Highway Patrol's motion to dismiss the lawsuit. The trial is scheduled for next June. If he ultimately wins, it could set an important precedent and inspire legal challenges in other states. From 2000 to 2019, by IJ's count, the feds sent a whopping $8.8 billion in civil forfeiture payments to state, local, and tribal law enforcement agencies that had seized assets under the joint program. During Lara's traffic stop, the officer asked if Lara had any firearms, explosives, or drugs in the car, and he answered truthfully that he did not. The officer asked whether he had large amounts of cash, and Lara said he did, explaining that he didn't trust banks. Because of his distrust of banks, Lara had kept his savings in cash for as long as he can remember. That's not as unusual as it sounds. Based on a 2021 national survey, the Federal Deposit Insurance Corporation, or FDIC, estimates that 14% of U.S. households were, quote, underbanked, meaning they have at least one household bank account but use alternatives. And another 4.5% were unbanked, with no bank accounts at all. Significantly, both the unbanked and underbanked rates are much higher at all income levels for those who are Black or, like Lara, Latino. In the FDIC survey, the unbanked cited distrust of banks as the second most common reason they shun conventional accounts, second only to bank fees. Under the civil forfeiture law, the government can seize and keep your property if it merely suspects the property is connected to a crime. The kicker? Often, the government doesn't have to offer any proof. Nor does the property owner have to be charged with the crime for the government to seize the property. This differs from criminal forfeiture, where property is generally turned over to the government after a conviction. For full coverage, check out Kelly Phillips Erb's piece on Forbes.com. This is Kieran Meadows from Forbes. Thanks for tuning in.